Welcome to the Compliance Council on Command webinar series. Today's topic is qualified mortgage and ability to repay risks. This is the third webinar in a series of sessions centered around the ability to repay rule. So we did one session on the qualified mortgage standard, we did one on the ability to repay standard, and now we're going to briefly fold those together and talk about the risks attendant with QMs and ATR loans. So to start off with, what about the liabilities? So on both those presentations, we talked in detail about how this new regulation really creates a cause of action for borrowers to bring against lenders. So what is your potential liability for violating this regulation? Well, you have actual damages, of course, so that's just any amount that the consumer is actually damaged out of pocket. There's also certain special statutory damages that they can get. So the statutory damages in this instance is the sum of all finance charges and fees that were paid within the first 3 years after consummation of the loan. So that can be quite a sizable amount. Now, we still don't know exactly what the landscape of damages will be. I mean, that's the high end. That's the maximum that could be assessed. I think courts would have the capability to award damages in less than that amount, less than the amount of all finance charges and fees in the first 3 years. But that is the high end. That's what they'd be able to get for those special statutory damages. In addition, the borrower can get court costs and attorney fees. So that's very important for two reasons. One, as an attorney, I know attorneys are expensive. So attorney's fees can really add up. Two, anytime a statute or regulation awards attorney's fees, they're really setting up almost a private attorney general mechanism. So regulators don't need to monitor the marketplace as closely because they can really rely on plaintiff's attorneys monitoring the marketplace and bringing suits when there are violations because those attorneys know that they'll get paid. So that's not to say that regulators are going to be ignoring this rule. Far from it. They're going to be looking at this ability to repay rule very closely. It'll be highly scrutinized. But I don't know that they're going to track it from a loan-to-loan-to-loan basis that closely because of this attorney's fee mechanism. So attorney's fees are important because it's higher potential liability, and also it's just a higher probability of lawsuit when there are attorney's fees out there. Because attorneys, you're going to start seeing billboards up for these for this type of action. Having trouble repaying your loan, contact Shark and Shark LLC. And it's because of these attorney's fees, because they'll be awarded in these actions. Other liability, it can be a defense to foreclosure. So that doesn't mean that if a borrower brings a successful ability to repay claim, that they can just own their house free and clear and not have to pay anything. That's not what it means. It's really just in foreclosure, they can bring this cause of action as a defense or a counterclaim and seek those damages that are up above. They can seek those special statutory damages, a refund of finance charges and fees. They can seek attorney's fees. They can seek any actual damages as part of that foreclosure. So there is a statute of limitations in association with bringing a freestanding ability to repay claim. So borrowers can file a lawsuit against the bank on the basis of an ability to repay claim, on the basis that you, the bank, failed to make a reasonable and good faith determination of that borrower's ability to repay the loan. They have to do that within 3 years. So there's a 3-year statute of limitations on that action. In the foreclosure setting, however, there is no statute of limitations. So they can always raise it as a defense in foreclosure. And I think that's likely where it's going to arise most frequently in the community bank sector. If you think about it, when is a borrower going to bring an ability to repay claim? When they're not paying, right? And when they're not paying, that's likely when you're going to be foreclosing on them or bringing some other action. So I think that's likely where it's going to come up most frequently, and there's not going to be any statute of limitations on that at all. Okay, so we talked about in the qualified mortgage and the ability to repay webinars that QMs get a safe harbor and that ability to repay loans get a rebuttable presumption generally. So on this slide I've outlined as a refresher which loans get safe harbor protection and which get rebuttable presumption protection. So your small creditor QMs, your eligible loans eligible to be purchased by Fannie or Freddie, they get safe harbor protection. Your standard track qualified mortgages, those that are underwritten in accordance with Appendix Q and that are meeting that 43% DTI and the points and fees cap, those loans are going to get the safe harbor protection. Certain higher priced loans, however, even if they're a qualified mortgage, will only get a rebuttable presumption. So if you're a small creditor and the APR on a loan exceeds the average prime offer rate by more than 3.5, then you're only going to get a rebuttable presumption. If you're not a small creditor, then it's just a standard HPML threshold. If the APR exceeds the average prime offer rate by 1.5, then you're a HPML at that point, and you're only going to get a rebuttable presumption. So you can have a qualified mortgage and have it be an HPML, but the best you're going to be able to do as far as legal protection is a rebuttable presumption. So to digress a little bit, you may wonder, well, what's the purpose of getting an HPML as a qualified mortgage then? They give you a little bit of break on the higher priced appraisal rule. Well, you'll be exempt from some of the appraisal requirements for HPMLs if it's a qualified mortgage. That's really the only reason. Otherwise, if you have an HPML, you might as well just drop down and do the lesser burdensome ability to repay standard, because rebuttable presumption is the best you're going to get anyway. So HPMLs, subject to that small creditor nuance, you're looking at a rebuttable presumption, and then all other loans that don't fall within those qualified mortgage buckets are going to be underwritten in accordance with the ability to repay standard and are going to get a rebuttable presumption. So what do these mean? What does it mean to get a safe harbor? What does it mean to get a rebuttable presumption? Well, to start, it's really, we can't really fully analyze all the risks between and rewards of safe harbors and rebuttable presumptions until we see some precedent develop. So this is a new law. Until we see it work its way through courts a few times and get some idea of how they're being litigated, how courts are treating these issues, then we'll get a better picture of what the risks are. But based on what we know now, safe harbors and rebuttable presumptions, they're not new legal concepts. So I can at least tell you how they generally work and what level of protection you'll get. So let's just take an example. I'm your bank's borrower, okay? I get a mortgage loan from your bank. A 1.5 years into it, I'm not making my payments. You initiate foreclosure proceedings against me. I, in that foreclosure proceeding, defend and counterclaim on the basis that you did not reasonably and in good faith consider my ability to repay the loan when you made it, okay? That's where we're at. So now it's on you. So now you say, well, wait a minute, we made a qualified mortgage. So, and obviously I'm simplifying the legal proceedings here, but you would say to the court, we made a qualified mortgage, we get safe harbor protection, okay? Now it kicks back to me, the borrower. There's still some evidentiary stage there, okay, where you need to prove that you made a qualified mortgage. And I may have some ability to do some limited discovery and try to disprove the status of the loan as a qualified mortgage. For small creditor loans or eligible loans, that may be difficult. For standard track qualified mortgages, maybe you messed up the DTI calculation. Maybe there was an error with points and fees. Perhaps Appendix Q wasn't applied properly. So there's still some evidentiary stage there possible in the safe harbor scenario. But once that's proven, once the loan status as a qualified mortgage is proven, the judge said, yes, this is a qualified mortgage, you are out. You, the bank, have a defense. You're out. My claim is going to be dismissed. Okay? So a safe harbor doesn't mean an absolute defense against any legal costs, because I'm still your borrower. I'm still going to be able to bring a claim. You're still going to have some legal costs in defending that claim, and there's still the possibility of that evidentiary stage where you'd have to prove the qualified mortgage status. But with the safe harbor, once it's proven that you have made a qualified mortgage, the claim is over. You're out of court at that point. So rebuttable presumption, same scenario. I'm your borrower. You foreclosed on me. I've asserted ability to repay against you. There's still going to be that evidentiary stage. So you, the banker, you're going to say, well, we made this in accordance with the ability to repay standard. We get a rebuttable presumption. All right. In theory, I'm still going to have the opportunity to poke at that and say, well, no, you shouldn't even get a rebuttable presumption because you didn't verify my employment, or you didn't take into account simultaneous loans. Any of those 8 ability to repay factors, if you didn't consider it, I could say you don't even get ability to repay rebuttable presumption protection. Okay? After that evidentiary phase, so you've provided documentation to the court, and you did consider the 8 ability to repay factors, and court agrees, yes, this is an ability to repay compliant loan. Now, unlike qualified mortgages, you're not out of court. So I, your borrower, I still have the opportunity to poke holes in your underwriting. So what you're going to get at that stage, once you've proven that it's an ability to repay loan, you're going to get a rebuttable presumption, which is just a bit of a thumb on your side of the scales, right? It's more of a hurdle that the borrower has to jump over to be able to get damages against you, okay? But it doesn't end there. So I, your borrower, I can still say, I can challenge your underwriting standards. I can say, yes, you considered those 8 factors. Sure, you get a rebuttable presumption, but the way you consider them is completely out of whack with prudent underwriting or with industry norms. So, I mean, maybe you completely ignored my student debt obligations, right? And they're sizable. You know, that could be a problem. I could poke holes in that. And that'd be really, you know, it could be either me challenging the way you applied your underwriting to me individually, like maybe there was a miss or a problem, or I could potentially just challenge your underwriting standards at large and say, hey, you complied with the ability to repay rule, and you even complied with your own policies and procedures. But I can still say your policies and procedures are unreasonable. You still didn't make a good faith determination of my ability to repay. So the big question is, we don't know how much of a thumb on your side of the scales that rebuttable presumption will be. We don't know exactly what that evidentiary stage in the qualified mortgage and ATR scenario is going to look like. How much of a fishing expedition are courts going to allow in that stage? You know, we don't know how litigants are going to bring these claims and what they're really going to focus on. So all of that, you know, probably towards the tail end of 2014, we're going to start seeing some of these lawsuits happen. You know, big banks are going to start getting sued for these, and some of that will start to crystallize, and we'll start to get a better picture of the landscape of what the litigation risks are. But, I mean, we do know that a safe harbor is higher protection. right? Because you're going to have less risk, because once you've proven it, you're out of court at that point. So even if you are very, very confident in your underwriting, which most of you probably are, and I tend to think that most community banks, don't quote me on this, but I think if you're underwriting loans and you're making good, strong loans, that you're not going to lose ability to repay claims, at least very many of them. I mean, you should, if you're documenting them and underwriting them strongly, you should be able to prevail in those ability to repay claims. But there's still going to be some legal cost and legal risk in the ability of the borrower to continue to pursue those claims after you've proven that it's an ability to repay loan. Unlike a QM where I would just be out. They'd just be out of court. My claim would be dismissed. So there's risk there. And it's just going to be an extra bargaining chip that the borrower's counsel is potentially going to be able to use, that they can press this claim going forward and, ramp up your legal costs incrementally. So what can you do in either instance, whether it's a QM with a safe harbor or an ability to repay loan or an HPML QM with a rebuttable presumption? You need to be able to demonstrate that after you've considered debt and income, the borrower has enough income left to pay the mortgage and meet their living expenses. So document, document, document. You need to be able to really document that you've considered the 8 factors on the ATR side, or that you've underwritten it in accordance with Appendix Q on the standard track qualified mortgage side. So what are some potential defenses for the bank in an ability to repay claim? One, it may seem obvious, but it's a very strong defense, is the more time that goes on, so the longer that your borrower is repaying a loan, the less strong of an ability to repay claim they're going to have, okay? So if you make a loan to a borrower and they made payments for 10 years, but then after 10 years you foreclose on them and then they bring up an ability to repay claim, you just have to consider their ability to repay a consummation. If that claim comes up, you should have a pretty strong defense to say, listen, Judge, this borrower repaid it for 10 years. So obviously we considered their ability to repay and they were able to repay in fact. Something must have changed after the fact, after consummation, that caused them to cease being able to repay this loan. Okay? So that's a pretty good one. I think as the life of loans goes on, the risk diminishes. So the longer you hold a loan, I think your risk of an ability to a successful ability to repay claim is going to diminish over time. Of course, the risk of a freestanding claim, that'd be a claim outside of a foreclosure proceeding, that's going to diminish over time, but it's also going to cut off after 3 years because of the statute of limitations. Another good defense for the bank would be if you're using underwriting standards and your underwriting standards have historically resulted in low default rates. So if you can show that your default rates at your bank are at or below the industry norm or at or below those within your community or region, then it's going to be difficult for the borrower to challenge your underwriting policies and procedures. All right, they're still going to be able to, but it's going to be a lot bigger hurdle for them to be able to claim that your underwriting policies and procedures are faulty if, in fact, statistically, they're working. And then ultimately, if you can show that your underwriting standards are really based on empirically derived, statistically sound models, they're based on industry norms, that's going to be a strong defense as well. So what are the uh-ohs? So those are your defenses. What are some things that can be problems? So one would be the inverse of a long-term loan, risks diminishing, If the consumer defaults shortly after consummation, that can be an uh-oh. It's not going to be dispositive. So if you have a default, 4 months after you close a loan, that doesn't mean that you failed in your ability in your duty to consider their ability to repay. It's not dispositive, but it's going to be higher risk than if they've paid for a substantial period of time. If your bank has higher default rates, that could be higher risk. If you have consistency issues and you apply your underwriting standards inconsistently, that can be a problem. Anytime that you're if you have a lot of exceptions to your underwriting policies and you're granting those exceptions a lot, now that can be a fair lending issue, but it could also be an issue about the consistency of your underwriting and whether it is a prudent underwriting practice. If you've disregarded any substantial debts or income of the borrower, then that could be an issue, particularly if they provided that and you still disregarded it. So, that's a summary of the litigation risks. It's frustrating because we can't really sketch it out in great detail. It's a very blurry picture. But as I said, as time goes on, these risks will start to crystallize. And we'll continue to track these cases at Dickinson and keep you updated when these cases occur so that you can stay on top and see, what are these risks, and you can continue to reevaluate your decisions ultimately. So let's move on to some other risks associated with these rules. Another is fair lending risk. There's fair lending risk, it seems like, in all lending areas. And there is here as well. So this is one that, your banking trade associations were really pushing the regulators hard on, because the concern was you've created this new cause of action. You've heaped additional risks on us. In addition to credit risk, now we have this litigation risk. So some banks potentially might not want to take on that litigation risk and could make the decision, we're only making qualified mortgages. We're not going to do ability to repay loans at all. You can imagine, depending on where your bank is located, that decision could have a disparate impact on a protected class. So for example, that decision, if you were making a fair amount of loans in 2013 that would have been ability to repay loans, and now you decide we're not doing those anymore, we're only doing qualified mortgages, well, what if a high percentage of those borrowers that would have gotten those ability to repay loans from you are minorities? Now that business decision has had a disparate impact on minorities in your community. That can raise some fair lending risks. So I don't want to turn this into a fair lending presentation, but disparate impact is very elusive. It is not intentional discrimination at all. It's just if something has a statistical disparate impact on a protected class. You don't have to have any intention to discriminate at all. So what happens when there's a finding of a disparate impact, the tables turn back on you, the bank, and you have to provide a business justification for it. It has to be a very strong business justification, and you have to show that there was no less discriminatory alternative. So here, your business justifications for a decision to make only QM loans could be litigation risk, could be lack of market need. It could just be the unknown of whether their non-QM loans are going to be liquid in the secondary market. Things like that would be your business justifications potentially. So to give you some example of where fair lending risks can arise where there was no intentional discrimination, there's a Department of Justice action against this Luther Burbank Savings Bank. Now this was pre-ability to repay rule, but it gives you some idea of how this can arise. So this bank adopted a policy where they said, our smaller dollar amount loans, home loans, they're not profitable for us. There's not a huge market need. we're only going to make mortgages for loans that are $400,000 or more in a principal amount. And this was a bank that was, I believe, generally in the D.C. vicinity. So a $400,000 house perhaps didn't buy you as much house as it would here in the great state of Iowa. So they adopted that, right? That's spatially neutral. That's not discriminating against anybody. That applies to everybody, regardless of, race, color, religion, creed, sex, gender. Applies to everybody. But the Department of Justice said, yeah, that's a facially neutral policy, but it has a disparate impact on minority borrowers in your area. Minority borrowers in your area aren't buying $400,000+ homes. So this policy has a disparate impact, and they got written up by the DOJ on it. So you could see where your trade associations were very worried about this qualified mortgage risk and with regard to fair lending. So they finally pushed regulators hard enough where the agencies released a statement. And they said, this is kind of the money quote from the statement, they said that they don't anticipate that a creditor's decision to offer only qualified mortgages would, absent other factors, elevate an institution's fair lending risk. So there are multiple qualifiers just within this one statement, let alone in the rest of the release from the regulators. They don't anticipate that absent other factors, it would elevate the risk. I mean, it's not the black and white statement that you're looking for, right? It does give me some comfort. I mean, it's better than the absence of a statement. And they even said in the release that, we didn't bring any fair lending claims against anybody when the HPML rules first came out, the higher priced rules, and some banks decided not to make those. They said this is similar to that. But so it does give me some comfort, even though it has multiple qualifiers in it. But I don't think that you can just ignore fair lending with your decisions regarding the ability to repay rule, or frankly, your decisions anywhere in lending. So litigation risk, fair lending risk, secondary market risks. So there's a lot of unknowns out there in the secondary market. Under that eligible loan exception, Fannie and Freddie is required to change their guidelines and adopt a qualified mortgage standard. When will they? What will they change it to? I mean, frankly, the bigger risk is what's going to happen to Fannie and Freddie? What's going to happen to the mortgage, the whole mortgage industry? I mean, a lot of legislation is floating about that could completely change the landscape of mortgage lending in the U.S. So that's a risk. Another risk is what will be the market for higher priced loans and what's going to be the market for non-qualified mortgage loans. So right now, primarily, entities are buying up qualified mortgages. There's not a real strong buyer right now for ability to repay loans. I have no doubt whatsoever that somebody's going to fill that need in the marketplace. Right? Banks are out there, and you're making ability to repay loans. Somebody is going to need to provide that secondary market function to buy those up. So I have no doubt that that'll happen, but what are going to be the terms of that? What are the warranties and terms that those purchasers of ability to repay loans are going to require? Are they going to be so cumbersome that you're going to be retaining more of these loans in portfolio than you otherwise would? It's a lot of unknown out there. You also have examiner regulator risk. So these are new rules to examiners, and sometimes we forget that examiners aren't some omniscient beings that automatically can digest all of these rules immediately and understand them and understand their implications. They're no better off than any of us are in reading these rules and understanding them, okay? So they need to break them down as well, and we don't really know what their approach to the regulation is going to be. We can read the text of the regulation, and we can comply with the text of the regulation. But as you know, there's always that layer on top of that of, safety and soundness, and, what are the examiners really looking for in addition to the black and white of the regulation. For some banks, are they going to question the bank's decision to make non-QM ability to repay loans? They've indicated that they don't intend to, but it's just another layer of unknown complexity out there with these rules. So again, what can you do with all these unknowns? Litigation, fair lending, examiner risk, secondary market risk. You need to ensure that your decision makers, that your board, your senior management, are fully informed when they're making decisions on these products and what you're going to do going forward. So those decisions have hopefully already been made, and surely your decision makers were fully informed. And hopefully you made a very strong record of the decision and all the information that was taken into account in making that decision. But keep in mind, just because January 10th happened and everybody's complying with these rules going forward, it doesn't mean that the decision ends. So all of these unknowns mean that these decisions need to be reevaluated over time. You can't just make a decision on January 10th that we're going to make QM loans and ability to repay loans. We're going to continue making the same loans we would have before. That can be a perfectly justifiable decision. But once some of these risks begin to crystallize, once the market begins to crystallize and you get to figure out, what things are looking like, you need to be nimble. You need to be able to reevaluate those decisions quickly. And frankly, you need to be nimble and be able to reevaluate not only to mitigate risks, but to take advantage of new opportunities you may have. So this is a whole new mortgage lending landscape for everybody, for you and all of your competitors, except for community development financial institutions. You're all in the same boat. So those institutions that are the most prepared, that have made the most informed decisions, and that are also able to reevaluate those decisions quickly are going to be better situated to take advantage of opportunities. So there may be, even in your community, market gaps and inefficiencies that arise because of these rules. Or maybe some of your competitors make decisions to maybe only make QM loans or not make higher priced loans. That could be an opportunity that you should look at and evaluate. You need to be nimble and ready to reevaluate and continue to evaluate your decisions and the risks. So this concludes kind of the three-part series on the ability to repay rule. So I encourage you to listen to this one on the risk. This is a good one that you could distribute potentially to board members or staff or senior management just to understand at a high level what are the risks we're talking about here. For those that maybe want a bit more depth on the parameters of the qualified mortgage standard or the 8 factors required under the ability to repay rule, you could go out and listen to those webinars as well.